Please put your hands together for NFP's President, Joel Shapiro, and Retirement Learning Center's Chief Operating Officer, Jenny Kiffmeyer.
Excited about ERISA, right?
Woohoo!
There is nothing more fun. So we decided, with it being the Jubilee, that we would kind of go with this party theme. And so what you're going to see is we're going to introduce new concepts via the concept of different types of parties. Before we get started, though, I'd like to thank the folks at RPAG for putting chairs up here. I don't know if it was in anticipation of my back going out. Some of you might remember the year they had to kind of prop me up here. Or if it was because ERISA is such a light and breezy conversational topic. But either way, I think Jenny and I are appreciative that we get to sit and kind of talk our trade with you. So Jenny and I both work with outside organizations, but they have been a key part of bringing ERISA solutions and conversations and new deliverables to you over the years. So this is a little bit of a bridge that started a little over a year ago. And you guys have been in great hands. And when I say you guys, I mean all of us, including myself. I'm now a member, not just the former owner as part of NFP. You're in great hands with Retirement Learning Center. You've got a really great tool and personnel at your fingertips. If you're not using them, you're missing out. So with that, let's jump in. We're going to start with the surprise party.
Woohoo! Yeah. So it starts out with the Supreme Court reversing its own 40-year-old doctrine called the Chevron Defense Doctrine. And so maybe to help explain this, I'm going to put it in context. I'm going to do a real quick civics refresher in 10 seconds. We've got the three branches of government. We've got the legislative branch, that's Congress. We've got the executive branch, the president, and then his agencies for enforcement. And then we have the judicial branch, the courts, for interpreting the laws. So a lot of times I shouldn't say a lot of times, but sometimes when Congress writes a law, it's vague, go figure, or they leave important points out. And so when it's time for the courts to interpret that statute, they struggle. And so a case back in 1984 that involved Chevron and the Environmental Protection Act, the courts wanted to look to the agency's interpretation of the law to then adopt how the courts were going to interpret it. And so this all went up to the Supreme Court in 1984, and the court said, yeah, when the statute is either silent on a particular issue or it's ambiguous, then the courts can look to the governing agency. So, for example, the Department of Labor, when it relates to ERISA, you can look to what the agency is saying in its regulations and defer to that interpretation. So yay, that's helpful. Well, fast forward 40 years, and what has happened is that the courts realized that they had given up a lot of their control, and a lot of the interpretation of the law had been handed over to the various agencies. Now, and the problem with that is that the agencies, like the Department of Labor or the Department of Justice or whatever, those agencies are political because they're appointed by the president. The heads of the agencies are appointed. So when a new administration comes in, there's a new interpretation of a law. And so you get this ping pong effect. And I think we see that with that Department of Labor regulation that's gone back and forth since 2016. And so now that we had the Loper-Bright determination from the Supreme Court, they went back and looked at how the law is supposed to be interpreted. And it's really under the Administrative Procedures Act that we get that guidance. The Administrative Procedures Act says that it is the court's responsibility to interpret. And not only that, the courts are supposed to oversee the agency's interpretations and make sure they're making a good interpretation.
So that's where we get the surprise.
Yeah.
Because everything in our industry, for the most part, in some way, shape, or form, revolves around what? departments' interpretations of statutes, right? You've heard me talk ad nauseum over the years, if you've been a member for a long time, about Department of Labor regulations or IRS regulations or revenue rulings or GCMs or private letter rulings, et cetera, et cetera, et cetera, right? This is all regulatory interpretation of statutes. And so the reason that I say it's a surprise is because now we can't necessarily feel as comfortable relying on all of that. And that has really kind of teed up a lot of what our practice has been. Think about the fact that if you had created your entire practice around what Kellen and Matt were just up here talking about, kind of in reliance on the 2013 target date fund tips, right? That's an interpretation to a degree of kind of the QDIA statute that came out. Well, imagine your surprise if you ended up in court about that, and essentially the trier of fact, the court, decided, I'm not giving any deference to that. That didn't even rise to the level of regulation. So, like, forget it. I'm going to completely ignore that, and I'm going to put in place essentially a court-created mandate for you moving forward. So there's a lot of potential upheaval as a result of LOPR. I think in addition to that, the unforeseeability is also going to maybe encourage more plaintiffs' attorneys' actions, right? Because everybody has been reliant on and been complying with and been trying to create prudent process around regulations and regulatory and sub-regulatory guidance. Well, if that's all kind of, I don't want to go so far as to say wiped out, but wiped out, Plaintiffs' Counsel now has kind of a free playground in which to play in bringing new litigation. So this is not the best fun surprise party that we've ever maybe thought about, but it's something that I think is worthwhile for all of you to be aware of, particularly as we're all governed by regulation as well, right? The fiduciary regs are a great example of that. If we don't understand what the rules are that we're going to need to comply with, it makes our footing a little bit more slippery. So this I think really requires us to pay some keen attention to it in the future. There's some rumblings on Capitol Hill about potentially codifying something that empowers the deference to the regulators, which I think is interesting. It's literally just in murmurs right now. But again, as Jenny mentioned, that could become a political football too. So let's move on to our next party.
Yeah. So we know that we've got the final environmental social governance regulations. They came out, they took effect last year in 2023. But there's been court challenges to it, kind of right apropos to the governance, or excuse me, the deference reversal. And so the challenge to the ESG regulations, well, let me step back and just give you a high level. So we've got the ESG rules that say that above all, a plan sponsor has to be prudent and loyal when they consider investment options for the plan. The decision has to be based on a risk and return analysis, and they can consider ESG factors if it plays into or is helpful with the risk and return analysis, or if there's a tiebreaker situation and the ESG factors are just collateral benefits. So plan sponsors can consider ESG factors. It's just that above that, prudence, loyalty, risk, and return are the most important. So as I was saying, that we have had court challenges to it. And so in the lower court challenge, the court found in favor of the Department of Labor's interpretation that they thought it was okay. The plaintiffs appeal, and the appellate court basically remanded the case back to the lower court to say you have to take a look at the Department of Labor's regulation to see if it is the best interpretation of that rule. So again, giving it back to the court to make a determination, is that rule what the Congress intended?
Yeah, and this is interesting. So the reason that we teed this up, pun intended, as the Super Bowl party is, the ESG arena has become our favorite political football, right? You know, we've seen it from administration to administration literally flip-flop in either direction, and now we're seeing it even mid-administration be challenged in the courts. This is actually, I think, a really good example of a scenario where we're going to kind of see how LOPR comes into play as it's remanded down. Now this lower court is actually, I think, empowered a little bit more to even take steps forward to kind of address whether or not these regs meet the ambiguity or the intent of the statute under which ERISA governs. So all that to say, for your practices, if you've incorporated any conversation about ESG with your clients, I'm telling you, and I just realized I have a whole lot of kind of bad messaging for you. We'll get to the good in a little bit. But what this does is it again, kind of makes the ground underneath which your process might become a little bit shaky. I think as a best practice, the way to continue to approach ESG is if your client is interested in it, you make sure that you are getting back to those core principles of 401A, which are about acting in the best interest of participants. If you use that as your guiding stone, you're probably going to end up making really good decisions, whether it involves ESG or not. And then you can fold in ESG into kind of the tiebreaker type scenario, because that has survived every single one of the administrations. It's like been edited slightly so that the words feel a little bit more or less favorable, but it's something that you can still rely on in your practice. So, you know, RPAG just came out a couple years ago with the ESG scoring. Absolutely continue to use that. I think that it's a really good tool regardless of where we end up with this. If for no other reason, maybe clients want to understand that for messaging to their participants, if they've got a vocal group of individuals seeking ESG, it doesn't necessarily have to play into the fiduciary process. It can be utilized in a separate kind of communications fashion. So with that, let's go on to our next party. And this one's a little bit more morbid.
But at least he's dancing.
Yeah.
So I mentioned previously the Department of Labor's Investment Advice Fiduciary Rules. We received final regulations. I have to start putting final in quotes. Final regulations in April of this year. They were supposed to go into effect September 23rd. However, we have 2 district courts now that have put a stay on the effective date. So basically, they're on hold. We also have a disapproval motion in Congress, as well as now we've got the deference reversal. So there's kind of like 3 strikes against moving these Department of Labor regs forward with respect to investment advice. Where that leaves us then is with the good old 1975 basic 5-part test. And we do have some of the new prohibited transaction exemptions, the PT 2020-02, but without the amendments from the latest version. So we're still holding pattern there and back to the 5-part test.
Yeah, so stop me if you've heard that story before, right? I feel like it's just a matter of time every time we get a new set of fiduciary regulations put out that they're going to be challenged and that they're going to be either kind of pulled back or amended, et cetera. The interesting thing I think about this set was that when the Department of Labor put them together, they purposefully made it severable. So if you remember a few years back when we got the last set of permanent final fiduciary regulations, it was not designed in that fashion. And so when the court found that there were a couple of elements that were overreaching, they were able to kind of strike down the regulation in its entirety. This one is built so that if there are specific challenges to it, those pieces can be vacated rather than having the entire regulation vacated. So before you get comfortable that we are having a wake for these regs, understand that it might be only for a portion of them. And so it really becomes important for all of you as fiduciary practitioners to understand which pieces end up falling out and which pieces remain. Because there are some that impact the way that we operate as advisors from even before we end up engaging a client moving forward. The sales process itself might be considered a fiduciary act under the current regulations. And if that portion ends up remaining, you're going to have to change the way that you're approaching sales. It's going to be a lot of documentation. You're going to have to figure out at the onset why this is in the client's best interest, or not even client, the prospect's best interest, and you're going to have to start detailing that in advance. So obviously, this is something that RPAG will keep a keen eye on because it's going to impact materials and collateral and strategies for all of you moving forward. So, before we, close the casket on this one, just be aware that there's probably more to come. That corpse of the regs might end up dancing like the skeleton.
And then just to keep in mind, you still have the SEC best interest,
Correct.
So lots to keep us on our toes.
Yeah.
Well, you cannot have an ERISA session without mentioning that 6-letter word, secure.
Or Jesse. No, that's 5.
Okay. So we want to talk a little bit about Secure Act provisions, both from the first iteration and the second one. So going back to Secure Act 1.0, it gave us one optional provision called the Qualified Birth and Adoption Distributions. So I find it interesting in Secure Act that the overarching intent of Secure, both 1 and 2, was to address the retirement savings crisis that we have in the United States, and to get more people covered and to get more people contributing at a higher rate. And then at the same time, it's almost like Congress was talking out of both sides of its mouth. It tucked in a number of distribution options to add to a plan that if you go overboard might lead to leakage that may not be in the best interest of participants in the long run. So that's kind of what this next section is dealing with. So in Secure Act, we had the qualified birth and adoption distributions. Moving on into Secure Act 2.0, we've got like 7 or 8 optional distribution provisions. We've got distributions for emergency purposes, terminal illness, for domestic abuse situations, 3 or 4 that are specific to public safety officers, qualified federally declared disaster areas, and long-term care coverage. So what I have advised or supported is that for plan sponsors to, number 1, realize these are optional provisions, and number 2, to keep in mind that you don't have to add these, and to always evaluate whether or not this makes sense to add to a plan, especially if the plan sponsor has adopted the theory that they feel responsible through retirement for the participant. And you're really promoting wanting them to have a secure retirement. Adding all these early distribution options, maybe it's in the best interest, maybe not, but when you evaluate them, make sure you do so, looking at the pros and cons.
Yeah, so I'm going to kind of pick up the ball where Jenny left off there, and I'm going to apologize in advance because I'm going to get a little preachy. So some of you have seen me kind of pound the pulpit before about things that I feel real strongly about. The reason that this says Holiday Road is, around the holidays, typically there's gifts. Secure and Secure 2.0, they're the gift for all of you as practitioners. And if you're not taking purposeful, thoughtful advantage of this with your clients, you are missing a tremendous opportunity to bring additional value and probably help them through something that they haven't given a whole lot of thought to in the past. There are an enormous number of provisions that are coming down the pike with multiple effective dates for both of these pieces of legislation. They're really big pieces of legislation, right? They are kind of game changers for the industry to an extent. For you not to dive in deeply on this and use it as a positive tool to kind of show the value that you bring to the table and the breadth and depth of how you can help them in more than just a quarterly investment review. And that is not to denigrate that portion, right? That is incredibly important. But now you're talking about how can they purposefully design the plan to meet the goals of the organization and to get the individual participants to where they need to be based on the company's goals for the plan. And so let me back up just a little bit and remind everybody that right now, and you probably don't need this reminder, but right now most of your clients are probably getting model amendments from their record keepers, right? How many of you have seen that with your clients? Okay, I'm actually surprised that more of you haven't.
Yeah.
If you haven't, either A, maybe you need a slightly better communication with the record keepers to make sure that everything gets in front of you. So if you haven't had that conversation with your record keeper partners, do so. You want to see those things before they get to your clients. But also, maybe your clients haven't brought it to your attention either, which is even scarier because that means that there's big decision-making points that they're navigating without your help and without your expertise. So what I'm going to say is one of the dangers of getting these model amendments out to clients so early is that clients tend to then anchor to them, right? They think, oh, this is something that I have to make a decision about today. And I don't fault the record keepers for doing this. They need to create internal efficiencies to make these changes to plans, right? So they're in some instances, with the optional items, they're creating kind of artificial deadlines to get these model amendments and usually connecting them with some of the non-optional elements that require amendments to the plan. But for your clients, they're receiving that and saying, oh, I've got to make these decisions. And quite a few of them are going to maybe do so outside of your earshot, and they're doing it more on an ad hoc basis rather than on a strategic basis. And that can be a little bit dangerous on the backside because each of these provisions are in different stages of maturation. And so this is a little bit of a new concept that I want you guys to think about moving forward. This concept of maturation is twofold. One, things have to mature with the service providers, right? So if it's a new provision, they've got to create internal technology, workflows, how they're going to handle questions. And that has a process, and the first adopters are often the ones that get impacted negatively by things that have glitches or things that need to be fixed. So you have to understand that that's probably the case and maybe communicate that to your clients. Do they want to be on the early adopting side of these? The second piece is from a regulatory perspective. So maybe not now that we have LOPR, but if a statute has an effective date, we usually are waiting to see regulations that expand upon what the statute said has to happen for that particular provision. Oftentimes, the effective date arrives, and we still haven't necessarily always received regulations. I always tell our clients, let's wait until we see this more fully fleshed out because we don't know what the potential ramifications are. In addition to that, even once we get regulations, there's usually clarification that's required on it. So even from a legal and regulatory perspective, we're waiting for maturation. And then there's the third element, and that's kind of the pragmatics of maturation, because a lot of these require not only change from the record keeper, but maybe from your client's internal payroll or their external payroll companies that interface with them and have to implement them. So there's so much that has to occur to get to close to perfect for these to run really smoothly for your client that you want to help them monitor that and remind them for the optional items, you don't have to make a decision today. It's not like these are going to get taken off the table and you're going to miss your opportunity to add them to the plan. Be mindful of it. Years ago, we talked about something called courageous plan design. And I think that this is a great opportunity for you to kind of re-adopt and reintroduce that concept. Remember that most of your clients' personnel probably weren't there when the original plan was put together. So they weren't necessarily the ones that purposefully chose the provisions that they have in their plan. Now they have this opportunity and maybe even requirement to amend their plan and to do some pretty big amendments. I mean, we're talking about construction on the plan. Now you can approach this in one of two ways. You can approach it as kind of adding a wing onto the plan with all these new optional elements, or, and this is what I recommend, approach this more like a kind of a rebuild. right? So these folks that now are running these plans but maybe weren't there at the ground level to design the house, so to speak, take them back and start asking them questions about what's the purpose for the plan? What's the driver? What do you want this plan to do? What do you want it to be? And now let's kind of utilize that to navigate how we want the design moving forward. And it doesn't have to be contained just to all of these provisions that are optional.
Right.
It can go all the way back, and you can do a full redesign and a restatement of the plan. And now that plan moving forward is going to better reflect the current ideals of the organization, of what they want the plan to do and how purposeful they want it to be. So to Jenny's point about the Secure Act and Secure 2.0 being primarily about let's figure out ways to get more money into plans so people can save more effectively for retirement, there were all these other provisions that allow for leakage. Mm-hmm. Individually, if you go by one and you look at them, you're going to have everybody in the room nodding yes. If you individually presented one in each of your meetings through the year, they all have good, reasonable foundation, right? Mm-hmm. I mean, who doesn't want to help someone adopt a child or pay for childbirth? And who doesn't want to help someone that needs long-term care insurance?
Exactly.
I mean, these are all good, fundamentally sound reasons to give people access to money. However, to Jenny's point, if you pull them all together, you have now created a lot of ways for people to take money out of the plan. And essentially what you've done is you've shifted what the purpose of the plan is from saving for retirement to saving for a whole bunch of things that participants might want to take money out for in the future, and essentially kind of robbing themselves of their future retirement assets. Now, that said, I am not espousing one or the other. What I am telling you to help your clients understand is what they want the plan to be for their company. Because there are other programs that they can create for all of those other elements if they really want this to be primarily and purposefully a retirement savings plan, in which case maybe they shouldn't create all of these leakage points. But what we really want to reiterate is they need to understand that this is an opportunity to create the plan in the current company's kind of philosophical image. And there's no one that's better suited to do that than all of you. So that's getting off my pulpit.
I totally agree, and the sponsors are looking for someone, help me understand this, or help the committee understand this so we can make the right decisions.
Correct, and look, the record keepers are going to be great about kind of explaining the nuts and bolts, but they're not going to dive all the way into that philosophical conversation. So if you're not having it with them, it's probably just not happening at all. So it's a big swing and a miss if you're not taking advantage of that. And then, as we approach year's end,
it's amendment time. Not till 2026 for most plans, but so this is the mandatory amendment deadline to incorporate the mandatory provisions into the plan, and then any of the optional provisions that an employer may have put in place, also to incorporate those by December 31st, not the end of the plan year, December 31st of 2026. There's, for collectively bargained plans, there's a little more time. I think it's till the end of December 31st of 2028. And for governmental plans, it's December 31st of 2029. So important to keep those amendment deadline dates on the calendar. But before that, if a provision is adopted and it's already been implemented, making sure that that's documented in the plan's record so we have clear timing of when this took effect, was the communication sent out appropriately, were elections made appropriately if they apply, et cetera.
Yeah, so there's a lot kind of in the rearview mirror. There's still a ton more ahead of us. We do want to acknowledge that it is the 50-year anniversary of ERISA. Happy birthday, ERISA. Without it, all of us might be looking for alternative employment, so don't get frustrated about new regs. It is your permanent employment guarantee. So with that, everybody have a great party the rest of RPAG. It's great to see you guys. Don't be a stranger. Definitely get questions in. Jenny's team is awesome. Thank you.